Welcome to Power Up with NSA North Texas, a show about finding, hearing, and maximizing valuable insights from some of the world's leading business and lifestyle speakers. Each week, international keynote speaker and National Speakers Association North Texas Chapter President Betty Coffey sits down with some of the most exciting speakers this side of the globe to hear from these subject matter experts what's making a difference in business today and learn all there is to know about people, profits, and productivity in business from some of the world's best motivators. This is Power Up with NSA North Texas. And now, here's your host, Betty Coffey.
Hi everybody, I'm your host, Betty Coffey, President of NSA North Texas, and I want to welcome you to our NSA North Texas show. The NSA National Speakers Association is the premier organization for professional speakers. Our members reach audiences as coaches, consultants, thought leaders, authors, trainers, educators, humorists, and motivators, and we do it every day. This show is going to give you the opportunity to hear some of the cutting-edge topics, the issues, the messages that are important today that clients want to share at their meetings, at their events, and they come to NSA to do that. You're going to hear from our own subject matter experts on these topics. And I am so excited today to have as our guest Russ Riddle. Mr. Russ, his bio. Want to hear about this guy? He's fantastic. So I got a question for you. What does Barney the Purple Dinosaur, Thomas the Tank Engine, and you, our audience, have in common? All of them have been served or about to be served by Russ Riddle over here. Russ has practiced marriage for 35 years. That's pretty good in itself. He's practiced law for 27, fatherhood for 26 years. He's braved adventures as a juvenile probation officer. He's been a newspaper columnist, and he is a professional speaker. Russ is convinced that we must never stop learning and laughing, and that's what makes my guest today so very, very special. His love of levity stems in part from the intellectual property law practice that has served such clients as, here we go back to Barney, Bob the Builder, Barney the Dinosaur, Thomas the Tank Engine, and the voices of Jimmy Neutron and Larry the Cucumber. I got to tell you, I haven't watched all these. Russ currently serves as the National Speakers Association Board of Directors, and he is the incoming chair of the editorial committee for Speaker magazine. Russ is the author of 2 books, Lawyer Up, The Smart and Persuasive Way, The Smart Way and Persuasive versus Abrasive, The Judges Have Ruled, and the Intellectual Property Manual of Corral Your Cash Cow. We're going to hear about those a little bit later. He's appropriately known, which is so interesting, as an anomaly at law. Did I say that right? Anomaly. For he's down to earth, which you're going to find out. He's really down to earth for a lawyer. He clearly communicates, and he lavishes others with his levity. So his topic today is corralling your cash cow. And just to kind of give you an intro to this, as a business owner or a C-suite leader who's stewarding the organization, your most valuable asset, aside from your people and your organization, is going to be your intellectual property. This podcast is going to help you saddle up, and I love saddling up, to better protect, manage, and fatten that cash cow. Your valuable takeaways that you're going to have after the show today is going to you're going to be able to distinguish between intellectual property types, and there's a bunch of different ones, ensure ownership from the outset, employees versus contractors, ace copyrights and avoid copy wrongs, and master the trademark of do's and don'ts for trademarks, and stop rustling others' cash cows. Okay, Betty's tired of talking now. So, Russ, I'm so happy to have you on the show today.
Well, thanks for having me, Betty.
Welcome.
It's a pleasure to be here.
Okay, you got to talk Betty talk a little bit throughout this show, because I'm not a lawyer, and sometimes this goes way over my head. But what is intellectual property?
Well, it's pretty easy. It's just intellect, property like it sounds, property of the mind. You have real property like land and buildings. You have personal property like your personal effects. Intellectual property are things that came from the noggin, things that you put down on paper.
Okay, so that should be easy for me to remember. So are there are different types of intellectual property, right? Are there 4 types?
There are 4 major types: copyright, trademark, trade secrets, and patents. Copyright talks about content, protects content creators, what they gave birth to, if you will.
Okay.
Trademarks are indicators of source indicators, a brand, where something comes from. Trade secrets are just that. Trade secrets, probably the most famous, is the Coca-Cola formula.
Oh.
There's not very many people that know that. It's a valuable trade secret. And then patents protect inventions.
Okay, I can understand that so far. So let's go to my next question, which, how does a copyright actually differ from a trademark?
Well, again, they're both intellectual property types, but copyright protects content. So, it's easy to remember. They both start with C, copyright, content.
Okay, I can remember that.
Yeah, that might be text. It might be the text of a book. It might be photographs. It could be illustrations. It could be art. Anything that is recorded in a tangible medium that's content, copyright protects. Unlike copyright, trademark protects symbols, logos. Think of the golden arches of McDonald's, or the superscript Disney on the side of a DVD or something like that. Indicators of source. We rely on those trademarks as to the quality and source of those goods and services. So they differ in that way. One protects what the other one doesn't. They do have some overlap, but not a whole lot of overlap.
Okay, so far, I think I've got it. The more C's you can put down for Betty, the better.
There you
so
go.
Copyright means content, and I've created it. So it's CCC.
There you go.
Hey, so far so good. Okay, so how does a person copyright their material?
Well, it's funny that you worded it that way, because there's this myth out there that one has to register with the Copyright Office to copyright their material. Mm-hmm. That's a myth. Copyright, I'll give you the legal mumbo jumbo, and then we'll give it plain language.
Okay.
The law says that the moment that it is fixed in a tangible medium of expression, copyright springs into being, kind of like a jack in the box.
Okay.
It's there. And what that means is when ink is on paper, when something is saved in a hard drive, a thumb drive, if it's saved in a tangible medium, mm-hmm. copyright exists. You've got it. You've already copyrighted the work. Now, registration is important, because if you ever had to sue under the Copyright Act, you have to have registered for that. And if you win that lawsuit, you can get statutory attorney's fees, get your attorney's fees reimbursed, and
right.
also statutory damages. Sometimes it's hard to prove what your damages are, and the copyright legislators knew that, and they built into the act. Judge, I'll just take the statutory damages, and then you don't have to prove it. You just get what.
Oh, okay. I got you. Now,
so there's some advantages of registering.
Are copyrights expensive to do?
No.
What's the cost of?
Well, yeah, I don't think so. They're $55 per registration online. It's a very intuitive thing. The copyright form is very easy to understand, easy to answer the questions, and you just follow through the flow. You upload a digital version of what you're registering, and you pay the fee online, and a few months later you get a certificate back.
I could do that. Do that. Betty could do that. Okay, so that's a copyright. I think I got that down. Now, with copyright, what are the implications of outsourcing creative work to independent contractors? In other words, I know speakers, we deal with a lot with virtual assistants, independent contractors, and there's a lot of people, hey, we're not specialists. We don't know everything about everything. So we have to work with contractors. However, it's scary, isn't it?
Well, it can be. It can also be very surprising and shocking down the pike if you don't do things correctly. Remember, copyright was brought about to protect the creators of a work. Mm-hmm. And if you think about it, when you outsource something, and we are in an outsourcing business environment, we do a lot of that.
That's right.
It might be website design, it might be photography, it might be illustrations. It could be a lot of things that if it's a creative work that we've outsourced, we're not the creator. The independent contractor is the creator. And so if you don't have certain things in place, the presumption is that independent contractor owns it, and you might get the tangible thing, you might get the video, the photographs, whatever it is, but you
Right.
don't own the underlying copyright, and you want to own the underlying copyright.
How do you do that?
Well, when you contract this independent contractor, you want to have it in writing. It cannot be an oral agreement.
Is it a big, huge, long legal form?
No,
or
it doesn't
easy?
have to be. It doesn't have to be. Some oral contracts are enforceable. Not so with work for hire. So it has to be in writing. You need to have work for hire language in there that says, Betty commissioned me to do this. I'm doing it for her. She will own it. And then I always advise my clients to also put in an assignment clause. And the reason we don't have time to get into it, but there's only 9 categories under the copyright law that qualify for work for hire. You and I can call something work for hire, but if it doesn't qualify under the law, it's not work for hire. And so that assignment clause, either way, you got belt and suspenders protection there.
I love
if the
that.
belt doesn't work, the suspenders will.
That's good. And that's why I love dealing with. That's why I'm so excited to have Russ on the show today. I mean, he makes all these very, very complex legal things easy. They're Betty size. They're easy to understand. So thank you. Thank you. So let's switch into trademarks.
Okay.
So what steps should be taken to establish a trademark?
Well, again, a lot of people think you have to register to have a trademark at all. That's not true. Trademarks arise by using it in the marketplace. Just start using the brand in the marketplace. Now, you're going to want to do some due diligence, or you might get a cease and desist letter in the mail.
Right.
You go on, use Google to search and see, is there something else out there that's exactly this or confusingly similar to this? Also, check out the database on the trademark site at uspto.gov.
What is that one again?
It's uspto.gov. It stands for United States Patent and Trademark Office, and GOV is short for government.
Gotcha.
But they've got a database that's easily searchable. But you might want some help because it's not just exact matches. Is there something that's a likelihood of confusion between the two marks? And you might need some other eyes on that, some opinions. But you still might want to register with the trademark office, because if you rely on simple use in the marketplace, it's going to be regional. It's going to be, where have you actually used it? Sometimes it's just in your city. Sometimes it's just in your state. Where if you get it registered, you've got federal all over the country.
I love it.
Trademark.
Okay.
And there's 45 classes of goods and services. It gets complex fast.
Are those expensive?
Much more so than copyrights. Yes, they are. There's different levels of filing. The most economical level of filing, where you have any flexibility in how you describe your mark and describe the services and goods, is $275 per class per mark. So $275 already is more than $55.
Right.
But
Yes.
you typically, let's take the speaking profession. You would probably grab at least 2, maybe 3 classes. Class 41 is what you do on the platform or in the training room. Class 16 protects books and other written products. Class 9 would be downloadable podcasts and video casts and those sort of things. So, cha-ching, they don't give you a volume discount. It's $275 times however many classes you want to protect.
Right.
And you probably need help of a professional, because it's not as intuitive. The trademark office is real quirky.
Okay.
And so you have to know your way around.
We are so lucky to have you in our North Texas chapter. My gosh, we're lucky. Okay, so I got another question for you.
Sure.
I've seen things with the big TM on it, or the SM, or even the R with the circle around it. What are those, and what's the difference between them?
Well, they're all designations of trademark, but you have to be careful. You can use the superscripted TM symbol the moment you start using it in the marketplace. So, when you're claiming trademark, you can start using that TM immediately. SM is just kind of a subcategory. I mentioned
I've seen a lot of those.
I mentioned briefly that there are 45 classes of goods and services. Classes 35 through 45 are purely services, and there are some businesses, they don't have any widgets, they don't have products, they just provide services. And sometimes people like to be specific and use SM, service mark, but it's not. They're interchangeable somewhat. You can still use the TM. The circle R. Cannot use the circle R unless you have a registration. And so that doesn't mean when you file an application. The application process is a several months process. It's a governmental agency. They're overburdened. They get hundreds of filings a day. It's going to take a while. It's at the very end of the process when you get that magical certificate of registration. And only then can you use the Circle R. Here's the reason.
Yeah.
Trademarks, they're valuable to business owners, no doubt about that. But they're not for the business owner, really. They're for the consumers. That you and I as consumers have the right to rely on a trademark to know the quality of good that we're buying. Mm-hmm. You go into a store and buy a Disney DVD, you don't feel as though you got to go preview that before you give it to a grandchild or a child, because you're relying on the Disney mark. That's what trademarks are about. So if you have a Circle R on something and it's not registered, you're really deceiving the public.
I'm following you so far. Yay.
Good.
So here's a question. I often see people using excerpts from TV shows and movies, oh my gosh, I remember going to a movie and I remember going to a meeting and they wanted to pump up everybody that was coming to the meeting. And as soon as we opened up those big meeting doors, dun 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 dun, right? The theme from Rocky was going. And were they supposed to do that? I guess that's one of my questions. When you see things from TVs or movies that are being used, do they own the copyrights? Can they do that? Is that legal? What do you think?
Well, I doubt seriously that they own the copyright. So I never judge people. I assume that those that you're describing have the proper license in place. But I see it all the time too, and I've got to think that not all of them have gone through the proper channels. Not all of them have the right license, and it's risky. Mm-hmm. A lot of people say it was just a smidgen, just a little. That's not the point. You don't own the copyright. You need a license. We'll maybe talk about fair use later. Some people say, well, it's just a small amount. Well, you may be right about that. You may be wrong about that.
But you're still doing it.
It's a risk. This is what we're talking about when I say corralling people's cash cows. You you play fast and loose. You think mythically it's okay because it's just a short piece. Everybody does it. And by the way, everybody does it's not a legal defense. The judge is going to pour you out with that one.
Bummer.
Yeah.
Okay, I got it. So dot your I's and cross your T's on that, right?
Do it the right way.
Okay. Similar question regarding presenters when they use music that's famous music. I know I've been tempted in some of my websites, especially on the Communicating with Horsepower program, to use something that's motivational and having music on it. That's a no-no, right?
Well, unless you have a license. That's a performing rights license. When you walk on stage and music is played, that's performing rights. You can get a blanket license. A lot of times the venue has a license that might cover you, might not. But you're talking about performing rights license. And again, I give people the benefit of the doubt. They've got a license. I hope.
Or we'll be in court, right?
Well, you may or may not be in court, but you may get a letter and you have to make some payments.
Yeah, I understand. So once again, do your due diligence.
Well, think of it. How would you like your intellectual property to be treated?
Betty would not be
You
happy.
want it to be buttoned up. You want people to properly license it from you.
Yes.
Yet sometimes we get fast and loose with other people's.
Yes.
Why? I'm not sure.
Okay. Fair warning. I got it. Okay. Russ, I often hear the phrase or the justification of fair use. Fair use. Okay. That's out there a lot, but I'm not exactly sure what it's all about. What's about fair use?
Well, there's a lot of mythology around fair use. People think that's a substitute for a license. It's not. It's not an alternative license. What it is an affirmative defense in an infringement lawsuit. And so you won't know if you're right or wrong about that being fair use if you're brought into court until the judge or jury decides. And it's decided on a case-by-case basis. Now, there's some factors they take into account, and we can get into those if time permits, but you need to be concerned. I never want my clients just relying on fair use. Now, I get two kinds of clients. I get clients that come to me after the fact when they're in trouble, and they say, help me show this was fair use. What do you think? Is this fair use? Well, I can give you my professional opinion, but it's very subjective. And if that judge had bad meatloaf that day,
You're in trouble.
there we go. And so, you don't ever want to rely on fair use, yet so many people do. People think that there are rules of thumb, like how many notes, how many words, and that's just a total myth. Now, fair use is in the Copyright Act from the very beginning for specific purposes, like news reporting, critique, like critiquing books or plays, research, teaching in a formal learning institution, not what we do on stage. We're talking about universities and secondary schools, and so that's what fair use came about originally. Now, it can apply to a commercial endeavor, but it may or may not, depending on what you used, and it's decided on a case-by-case basis.
Okay, so my next question, speaking of fair use, it's a trend out there. Doesn't matter what industry you're in. I see it everywhere where we use on our websites or on our social media or on our graphics, whatever we're doing, where we use other people's logos, other organization logos. It looks good. It makes you look important, but tell me about it.
You need to have permission to do that. The logos, again, are protected by trademark. There is some overlap with copyright if it's a content-rich logo, not just words, but if there's some real intricate design to it. So you may have some problems. Where I see this so much, Betty, is in the speaking industry, service providing.
Yes.
But professional services across the board sometimes get fast and loose. They want to make a big deal out of who their clients are, and I understand that. But there's a proper way to do it, and there's so many dangers to do it without consent. One is it might be trademark infringement, might not be. But if you've got it on there in such a way that it's kind of implying that they endorse you or you're affiliated with them, it could be trademark infringement. Another thing that happens a lot of times in the speaking world is we have engagement agreements, written contracts.
Yes.
And believe it or not, some companies don't want the world to know that they have trainers come in. They would rather just the world think they know it all.
Right.
So sometimes you'll see in those contracts that you are not allowed to make any publicity of the fact that you had them as a client. Well, if that was in the contract, breach of contract as well.
There you go.
You're going to alienate some clients. Some clients will love it.
Right.
Like, oh, this is so cool. You're using our colors. This is not cookie cutter. You've tailored it. Others cross their arms, pucker their face, look as though they're constipated. And have you checked with our legal department?
There you go.
And it's not going to go well. A couple of others real quickly. What if you have put together some real slick marketing materials and you essentially have to throw them away because you can't use them anymore?
So it's going to cost you a lot of money.
There's some money. And you might, particularly in the professional services arena, you might violate a code of ethics. That's certainly true in the speaking world.
Okay.
So you got to be really
Bottom line
careful.
here, call Russ.
Get permission.
Bottom line is call Russ and make sure you're doing it right, because you can really pay for it in the end. Okay, you've done some books. And so Lawyer Up, The Smart Way and Persuasive versus Abrasive. The judges have ruled. Talk to me about that.
Well, you mentioned that I'm kind of easy to talk to.
Yes.
Anomaly at Law. Let me tell you about Anomaly at Law real fast.
Okay,
I hope we have time.
please.
People would come up to me and we talk and we're getting along, we're laughing, and they say, "What do you do?" And I would say, "I'm a lawyer."
Yeah.
Yeah, they'd be shocked. And they say, "You can't be a lawyer. You don't seem like a lawyer. I like you. You're making me laugh. You're not a lawyer." Yes, I am. One lady came in and she said, "Honey, you're really an anomaly." And my light bulb went off.
I love that.
It wasn't me being clever. It just found me. Attorney at law, anomaly at law. It's kind of who I am. So I had people ask me, well, I get you in the intellectual property area, trademarks, copyright, branding, licensing, but I need a construction law lawyer, or I need a yada yada kind of lawyer. How do I find you in that space? And so I wrote a book called Lawyer Up, The Smart Way, and I gave some tips about how you can find someone not just like me, but the right fit for you. There are a lot of traps you could fall into, and this little read will help you avoid a lot of those traps.
And it's easy.
It really is.
And it's
it really
step by
is.
step, and it
Yeah,
helps us.
It's
I love that.
It's an easy read, and you can see I don't take myself too seriously in anything I do. You mentioned abrasive or
Yes.
persuasive versus abrasive. The judges have ruled. It seemed to me that in the lawyer world, but professional services as well, people think they're being persuasive, but they're not. They're being abrasive. They just start talking louder. They talk over each other. That doesn't work. So I interviewed 55 judges all over the state of Texas. I said, are you seeing the same thing? To a judge, they said, yes, let me tell you. And so this is a little fun read about some of that research. I'm working now on a full-length trade
That's
book.
wonderful.
And then finally, I have this.
Yes.
This is
Drum
what we've
roll.
been talking about today, Corral Your Cash Cow. This is a lot more detail, but what we've been talking about is captured in here and more. It's an intellectual property law manual.
Perfect.
Give you
Perfect.
some-
And how do people get your books?
Well, come to my website, russriddle.com. It's www.russriddle.com. 2 S's, 2 D's, as in dog. When you think of riddle, just think joke. I'm the Riddler. russriddle.com. You can find them there.
And how, if they want to reach you by phone, what's your phone number, sir?
Well, you could certainly send me a message through that, or you could call me. I'll give you my number. It's 214-663-4791. That's my only phone. You'll get me. You could also send me an email, russriddle@verizon.net. I have others, but that's probably the easiest one to remember.
You're awesome. You are so fantastic.
Well, you're awesome,
and you're
too.
you're interesting to listen to, and you're fun to work with, and you're real. You're authentic, you're real, and Russ is fantastic to work with. So thank you, sir.
Oh,
I
my
really
pleasure.
appreciate you
It's been
being
a
my
lot of
guest
fun.
today. Thank you. And everyone out there, thank you for joining us today. Remember, it's all about powering up to be better, faster, and stronger. Until the next time, thank you so much. Great job.
Thanks for listening to Power Up with NSA North Texas. To find out more about today's guest or NSA North Texas, visit www.speaker.org. To find out more about Power Up, visit our Facebook page at www.facebook.com/groups/NSA North Texas. And to find out more about Betty, visit www.bettycoffeepresents.com.